a water compact. I just want to interpret the word waive. That's all you see in a water compact. And what that means is you wave goodbye to the land. So that's all I'm going to say. Woo.
Thanks, everybody. Well, look, I'm just going to start by reiterating the ground rules for this discussion, if you don't mind. I'd like to remind you that we would like to have civil conversation here, respectful conversation. I'd like to ask you to save your questions and please let the presenter present through their train of thought, and then we can come back to your questions for clarification at the end. Okay? And then, secondly, I just want again to thank Little Bighorn College for making this opportunity available for us. And if the proponents, I'm making this up myself because I'm not in charge here, but I would guess that if proponents would like to have a similar session, they would probably be welcomed at the to make a request to the college. That's just my guess. Okay, I am pleased to welcome and to introduce William Eggers, who received his BA in Berkeley and his LLB and JD. That's a lot of letters. Means he's a lawyer from Hastings Law School, which is a part of the California university system. He is a former assistant United States attorney, former state representative from this district, a trial lawyer for 40 years, has taught federal Indian law and policy here at Little Bighorn College for 4 years, and is currently an adjunct professor at Montana State University teaching federal Indian law. Please welcome Bill Eggers.
Take your chair. I'm going to use the podium.
It's okay, I'll say it.
So I can read my notes here. This water compact is going to set a precedent in the nation. Let me start with that. First of all, on March 8th, it's a done deal. If you vote for it, there will never be a change for the rest of your life and have your grandchildren and your great-grandchildren. Secondly, maybe firstly, what's happened in this water compact has compared with other water compacts that have been negotiated.
Hey, Bill, excuse me, I'm sorry. You just have to hold it really close to your lips. I'm
right.
sorry. We don't seem to have very much volume.
All right. Thank you. The way this compact has been negotiated, excuse me, I'm hearing now, is that the Congress of the United States, pursuant to the Commerce Clause, the various decisions of the U.S. Supreme Court have ruled is the source of Congress's absolute power over Indians. Congress has plenary power. Plenary means absolute. This compact has been negotiated where Congress has exercised its plenary power. It's taken the water away from the allottees, and it's not given the allottees any money for the water it's taken away from the allottees. Excuse me. There are presently 75, let me check my notes here, 75 tribes out of 556 which have resolved their water rights claims either through litigation or settlement. That leaves approximately 415 tribes that have not. Since the McCarran Amendment was passed in 1952, that's about over 60 years ago, there are still 415 tribes that haven't resolved this yet. So I'm not sure what the rush is. There is no rush to the finish with regard to the Crow-Water Compact, and if there was a rush to the finish, then are they threatening lawsuits in all of the other 415 reservations? I seriously doubt it. So, I guess I need to make a disclaimer, I guess, because I've been accused of assuming that I represent the Crow allottees. I don't represent the Crow allottees, I represent myself. I've practiced over 40 years, I've been a trial lawyer, I can read documents, I used to do trial litigation with regard to contracts, and I can read that compact a little better than you can because I'm conversant with the terminology, excuse me, and the wording of the compact. So I bring to you and to this document 40 years of trial experience in writing laws. I've written legislation for various states. I've been in the state legislature, and I've litigated contracts for my clients. So let's start. I have tonight to talk to you about 8 different subjects. The first is the settlement and the timing of it. The second is the allottees' quantification and allocation. The third is the money involved. And Willis, Dr. Wade, has covered that. I'll cover it from a slightly different perspective. Fourth is groundwater. Fifth is waiver of claims. Sixth is breach of trust. Seventh is the constitutional violation. And the 8th are other consequences. So let's start with settlement. The McCarran Amendment, as I said, was passed in 1952, and ultimately this has to be settled because the federal government has directed through the McCarran Amendment, it is waived, the federal government has waived its sovereign immunity and said that the state and the tribe can negotiate the water within the borders of the 4 corners of the reservation. So the federal government has pulled back from this particular issue to let us struggle with the state. Now, we're not alone, because that is true across the face of the United States. Each tribe has to deal with its state government. What I'm seeing is whether the cases in the past were litigated or whether they were settled. In most cases, the tribe took care of the allottees. Allottees are beneficial occupants of the land who have a right to use the land for their beneficial use. In other words, crops or livestock. The title to that land that the allottees, like you and I are, the title to that land is in the federal government. Okay, and we start off with the title to the land being in the federal government.